Welcome back to the Supreme Petition. Just hours before we get to know what the Supreme Court judges have decided, and the big question on everyone's mind, what could they be doing? What are those processes that they have to go through before they tell us what they have decided? And there's one man who should know. Retired Justice David Onyancha. We spoke to him a short while ago. Listen to some thoughts from him.
Every judge is free, depending on the evidence which is before the court, to take a position. The deciding opinion then depends on how many of the judges, of the 7 judges, take that position. If more than 4, if more than, and the majority of the 7 are convinced to take a given position depending on the evidence, that is the deciding position. Well, when the parties go before the court, they know that what the court decides is the final. What the majority of the judges decide will be the final, will be the deciding opinion. And they don't have to go to persuade them. The party knows that the majority opinion is the final opinion.
All right, so the majority opinion is the final opinion. That is what even my legal experts here will tell me. And we will talk about that verdict or the options that those judges have in a moment. But Muthomi, you were itching to talk about 2013 because I remember the other day the two of you had a fight, even if Martin was remote, was on phone somewhere. Yes. But I think that one of the biggest things that I have heard people say about the 2013 decision was that they were short on detail. They did not develop the law any further than they had found it. That, as a matter of fact, they focused more on technicalities and so on and so forth. Is that what you are saying about this 2013 thing? And therefore, would there be parallels? Would there be comparisons? Would there be lessons that 2017 could pick from there?
Maybe before I tell you my position on the 2013 decision, it's important to appreciate that the controversies about that decision do not necessarily lie in the fact that they dismissed or allowed the petition, but in the reasoning process used in arriving at that conclusion. And in my view, the 2013 court made several fundamental errors of law and principle.
E.g.?
The operative word here is fundamental, Joe. Number one, they got the test for nullifying an election wrong because they read the so-called Section 83 of our Elections Act conjunctively. That is to say, they held you must prove both breach of the law and that breach of the law affected the result.
This is the one that speaks of affecting, that it has to be big enough to affect.
Yes. First of all...
why is that a problem?
Why that is a problem is, number one, it's not the correct reading of the law. It is not the correct reading of the English case of Morgan versus Simpson that they were purporting to rely on to arrive at that conclusion. Number two, that section is itself actually unconstitutional, in the sense that to the extent this section envisions that something which breaches the Constitution.
I wonder, and Martin, you can weigh in on this, I don't know what views you have on this, but what I wonder is that if there is a controversy about this Section 83, it was a controversy.
Right. That you cannot take the law in a manner in which it narrows down the interpretation of the Constitution and find with the law rather than find with the Constitution. Because rightly as the team has been canvassing around this particular one, is to say that in a petition case, the civil rules procedures apply and not the criminal procedures. And therefore, you cannot introduce issues other than on balance or probability in terms of proof.
My question and my worry, therefore, is, Martin, and that's what I was raising, that this question of Section 83 came up post-2013 decision, because people were talking about it, saying that the judges appeared, if I understand you correctly, to elevate that that provision in the Act above the Constitution. That's what I've heard some people say, but that they also stretched the interpretation. But my issue is that that was 4 years ago, and in between, I don't know, maybe I've not been listening, but I haven't had a heated conversation about this, which Mudhomi says is unconstitutional, because that is a serious thing to say.
Only.
So is it that there are people who like it that way?
Joe, let's put it this way. Let's put it this way. A case law, or what we call case law, is a decision of a court at a certain particular time. Now, the case law either establishes law or establishes the basis of divergence on law. So if a case is fundamental, it affects how other decisions are made. Now, when there's a submission that says that the 2013 case law is a solid bedrock of election
principles,
that's a false statement. That's a false statement. That's a statement that is challengeable, because even this very court in 2017 is not bound by its own decision in 2013, because there's wisdom, there's development, there's jurisprudence, so they can actually deviate from it. So that you do not hear much of this being ventilated does not mean that there are no issues legal in that. And yet, if you went to law school, or if you hung around the school of law, you would have been privy to the fact that these decisions have been so hard, so well ventilated, so well argued. Indeed, theses have been written around this decision.
But then that brings the question that, does that mean that that part of legislation has a certain force just because the Supreme Court appeared to have? Because I'm wondering why we haven't changed it. You understand? That is the basic question I'm asking.
Let me tell you the answer to your question.
Who is not a lawyer. Like, why do we still have it? And we have...
I'll tell you why.
Yes.
But before I tell you why, maybe I should tell you there are also historical problems. This section is as old as the year 1872. This section was reenacted by our parliament in 2011 to implement the Constitution of 2010, which is a very radical document from electoral law as it was known in 1872. So your question is, why haven't we, how did they find itself in our law? I'll tell you, not only that section, but perhaps the entire Election Act of 2011 and many of the acts passed by the 10th Parliament are unconstitutional in countless ways. And the reason is, if you check Schedule 5 of our Constitution, Parliament was required to enact a number of laws to give effect to various articles of the Constitution. What many people do not know is, instead of sitting down to reflect on what transformation the Constitution required in enacting these laws, all Parliament did was actually to reenact the old laws. So that if you picked your computer, Joe, right now, picked this 2011 Act and compared it with the previous Act, which was the CAP 7 Presidential National Assembly Elections Act, they are carbon copies. The only trick Parliament has done to fool us is they put the sections, to use an example, into a basket, shook the basket. So Section 83 was previously Section 28.
Okay, Joe, let me make this point. We have a new constitution.
Because I wanted to just replay 2013 ruling in a bit.
Just
you
before
can
you
make
do
that point. Yeah.
One of the things that you really need to accept, and you've seen it even from the courts, there are a number of laws that the courts have struck out, that Parliament has passed, on account of them being unconstitutional. There are a number of them, whether you're looking at land laws, whether you're looking at the provincial administration, whether you're looking at even an attempt to change the way the Chief Justice is appointed and so on. So there are a number of things. One of the things we want to accept is this, that there's a disconnect between our new constitution and our thinking. And that is our frustration. That many people would rather be in the older form.
That the new constitution is more radical than we are willing
and
to be.
Therefore, it hasn't sunk in our minds. It hasn't.
Okay, let's take a recap of what happened 4 years ago so that we get a bit of perspective.
What most Kenyans don't remember concerning the dispute surrounding the presidential election in 2013 is that a total of 3 petitions were actually filed at the Supreme Court following the announcement of Uhuru Kenyatta's win by the IEBC in March 2013.
In full realization of the high calling,
I assume as President of the Republic of Kenya.
I assume as President of the Republic of Kenya.
The first petitioners were Dennis Itumbi, Moses Kuria, and Florence Sergon, who sought the court's determination on whether rejected votes should be included when determining the total number of votes cast. The second petition by AFRICOG, represented by lawyer Kathy Kilonzo, sought to invalidate the presidential election on different alleged irregularities in the registration of voters, the electronic voter identification, and vote tallying. The third petitioner was Raila Odinga. He was represented by lawyer George Oraro. Raila wanted the presidential results invalidated, alleging that massive electoral fraud and malpractices aided Uhuru Kenyatta to win. So while the Supreme Court had 3 separate petitions on the 2013 presidential election, this time there is only 1 petition filed.
All right, 2013 there, just giving a breakdown of what exactly those judges were dealing with. 3 different petitions. This time it is only 1 petition, even though those ones were still consolidated. But does it make a difference that they had only 1 case to deal with? Would that matter at all?
It doesn't change anything. The important thing is whether the decision is consonant with our Constitution, because in my view, the frame of reference is the various articles of our Constitution. The second consideration is the precedent that the decision will establish. You see, when the highest court in the land rules in a particular way, all the lower courts are obliged as a matter of law to decide similar cases in the same approach. And that is why you see most of the election petitions that were filed from the 2013 general election were dismissed because the lower courts, including the High Court and the Court of Appeal, would find themselves tied, even when they thought that maybe the dictates of justice required them to invalidate the election. They would find that they are bound by this decision of the Supreme Court in petition number 5 of 2013. And earlier on, we were talking about Section 83. All I want to point out is, because we may not have the time to delve into all of them, that's just one of the fundamental problems with the decision of 2013. You could count actually no less than 10 serious misdirections and errors of law.
And I will invite you back once this ruling is given so that we can do a checklist and see whether there are any differences between that and this one. But let's try and take this home. I know that the Supreme Court said we shouldn't profile the judges and sort of discuss who they are. But are we in a country, as a country, in a place where we can even tell what judges really stand for? Do we have, when there's a ruling, can you really tell that this was a thinking of Martin Olo and this part is a thinking of the Ankolo? What is the...
No, Joe, when you have a 7 bench, you expect that each member of that bench will have a view. Now, where 2 or 3 agree out of 7, then that view becomes common among 3. Where the others disagree, then they have another view. So basically what you're looking at here is that there will be individual opinions. In some points, the opinions will agree. If it's out of 7, 5 agree, that's we call that a majority opinion. And the other 2 will have a minority opinion. Now, in both cases, then you need to deliver the majority opinion and also deliver the dissenting opinion. And in both those dissenting and in the majority, they become points of reference.
But we don't. It's in the case of the Supreme Court the last time around.
Yes.
I mean, I don't know whether we got a sense of who thought what, because I remember, for instance, the famous 6 minutes, whatever it was, yeah, this one dismissed, number 2 dismissed, this one allowed, but ABCD. But at the end of the day, I don't think Kenyans ever got a clear sense
Precisely
of what each of those judges truly thought about this.
Precisely, and
Isn't that a place where we need to
go?
go?
But that's the biggest criticism that was ever laid on that, because it was dealt with in such a cavalier way. They just came and 5 minutes they went. Kenyans said, no, that's not how to go. You've heard it even from the chair, the president of the Supreme Court saying, you demand of us a reasoned, so we will give you a reason.
Actually, Justice
Mwilu said it, and even the president has emphasized. So what you are going to see is certainly different. So there is, again, if you just look at the form, there's a difference between the form for 2013 and 2017, because this time judges are actually, even in their rulings, they gave written rulings, and they posted it out there. So you could see how they reasoned and how they got onto their rulings. So basically what you're saying is that it is not necessary to profile who is going to say what, but at the end of the day, out of 7, you're going either to have a majority of 4 saying one thing, and a minority of 3 saying
But I've had people say, Mudomi, that, and these lawyers, actually, some of them whom I've hosted here, that if you're able to tell that Martin Olo is this kind of judge, he thinks this way, then that as a lawyer, somehow it helps you to prepare better. Is that a fair thing to say?
Let me say that in more advanced democracies, and I could cite the example of the United States Supreme Court, judges are appointed on ideological leanings, so that you hear them talk of conservative, centrist, and radical or activist judges. Now, the distinction with ourselves, which I think is perhaps the biggest tragedy with our country, is we have this unique obsession with ethnic identity, so that when we have a discussion, it is never about issues, it is not about ideologies, but the ethnic origin. That, if I understood your question earlier on in the profiling, for me I think the problem is we seem to have a fundamental shortcoming as Kenyans. It is only in this country where I've seen when there is an important matter of public interest, and you call professionals, say the way you've called my senior and myself, before you ask the question based on the ethnicity, you actually know which side they lean. And it's only in Kenya and certain other parts of the third world where we would have an important election like the one we just had, and the issue would not be how the economy is doing, the issue would not be unemployment, the issue would not be housing, it would be which is the ethnic formation or coalition of ethnic formations. So it is unfortunate if we would resort to profiling our judges. If we must profile them, then I'd rather we profile them on basis of ideology and values they believe in, not on the basis of they come from this tribe.
No, that is in fact where I was coming from. But this, we have to end this. So finally, Martin, if you were to say one thing, that whatever verdicts those judges gave, what is this one thing that you as Martin hope they can contribute to law in the country going forward, so that when if we have another petition in 2022, or in fact, if we have one down the road, as Mudomi was saying, then we know that we are starting from a better place.
Yes. One thing, Joe, that I really am looking forward to this judgment is that we are going to have a significant contribution on how to improve on our electoral management system. Remember that some of the laws that we passed, including what was upheld the other day by the High Court and the Court of Appeal, was as a result of the 2013 decision. So this time round again, having seen what has happened around our IT, having seen some of the anomalies that may have happened, I expect that this Supreme Court judgment will actually be very strong on corrective measures and some of the fixes that ought to be done in order for us to have an electoral system that we can live with.
Okay, Mudomi.
For me, what I'm looking for, Joe, our Constitution says in Article 81, 86, Article 38, that Kenyans shall have an electoral system in which elections are conducted in accordance with a system that is transparent, that is fair, that is accurate, that is correct, that is verifiable, and in which there are sufficient structures and mechanisms to avoid electoral malpractice and free from intimidation, bribery, and other forms of undue influence. What I'm hoping to see is a decision that helps the country achieve that very lofty ideal that is addressed in the articles of the Constitution that I've mentioned, and in particular, a decision that helps us move forward as a country so that we are not in this vicious cycle of the same allegations, same problems every electoral cycle.
All right. Thank you very much, Mudomi Diankolu, Martin Olo, my guest tonight. Remember, tomorrow the verdict comes. We don't know what it will be, but we will be here to cover it. Do have a lovely evening. My name is Joe Agayo. God bless you.